Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in cause number CV210433 S&S Holdings LLC versus American Green. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes in which to present your argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. We have read the briefs. We have discussed this case in conference. We're familiar with the facts of this case. Please bear that in mind during your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Your Honors, Isaac Gabriel and Julie Walters appearing on behalf of S&S Holdings, the appellant. May it please the court. This court must decide if non-monetary breaches of covenants in a commercial lease, which remain uncured, can be enforced by a landlord in connection with a clear and unambiguous option. If so, then the applicable option to extend the lease at issue, which precludes the extension in the event of an uncured breach, was void, and this court must reverse the trial court.
So why did you take so long to complain about the sign?
Well, let's recall there's two issues here, but with respect to the sign issue, there's a couple of things. One, my client did not take so long to complain about the sign. As soon as my client discovered the sign had been removed, he immediately reached out in writing and notified the tenant. Now, was this a legal, technical notice under the lease? It was not. I think we can all admit that. But he noticed it right away. He was told that they would work on a replacement. He testified he followed up multiple times with that same person, Wade Kerrigan, as well as other representatives of the tenant. In addition, both he and the tenant both testified that sale discussions were ongoing with respect to the building. So if he's selling the building to them and they're going to own it, clearly they're going to put up their own sign. So
Is there anywhere in the record you can point to where he actually demanded, I know about the text messages and things, but where he said, you have to replace this?
Oh, well, in the default letter, in the October 15th.
4 years or 3 years later?
Approximately 3 years later, yes. Yes.
So back to Judge Howe's question is, why did he wait so long? Your answer is?
My answer is to send a formal legal notice?
No, to ever actually say, you need to replace this. Not, hey, I noticed the sign's missing, what's going on? But this is important to me, you must replace this.
He said that in his first communication. If you look at the text messages, he said...
Quote it to me.
He said, the lease, that's part of the lease, I need that sign. And then they followed up and said, the sign was thrown out by the company, we'll have to figure out a way to replace it. And he said,
and did he say?
And he said, okay. So the reason that it took so long is
he never demanded, put this up or you're going to be in breach of the lease and I'm going to kick you out until 3 years later.
That's correct.
Okay.
Yeah, in terms of enforcing the remedies, that is correct.
All right.
And when he did that, he provided a 30-day notice. So he followed the letter of the lease. And it's going to be, well, again, back to the explanation I just gave.
So it became material in 2020, but he didn't treat it as if it was material in 2017.
Well, as I just indicated, I think he did in terms of saying this is going to go back. This is an unsophisticated guy. He said he doesn't like lawyers. He said he followed up multiple times, and then they entered into sale discussions. So he was clear, if I'm going to sell the building, and even Mr. Gwyther of the tenant said this in his examination. I said, when you got the letter, why didn't you take it seriously then? And he said, well, we thought we were going to buy the building, so we wouldn't need to put the sign back up. So both parties acknowledged these sale discussions were going on. And if he's not going to own the building anymore, it becomes less important. But once you say...
In the 2020 demand, did he say you can cure and put this right up right now? Or make any demand to put the sign back up? Or a sign back up?
The default that was noticed was the removal of the sign. And the ask was
Don't you normally have to give an opportunity to cure?
There was an opportunity to cure. There was 30 days.
Okay.
And in addition...
But, no, I mean, did the demand say you can cure this by replacing the sign within 30 days?
I don't know if it used that verbiage. It said, it referenced the lease provision, it referenced the sign had been removed, and it said, we demand that you cure the default. The lease says the Shoals signage is supposed to be on the building. So I don't know if there's any other way to interpret that, which is take your sign down, put our sign back up, or a replacement sign. And there's a question in there that you're asking about the timing, which is if they're going to renew. So if they want to renew and it's clear you're not going to sell the building and you're going to be occupying it for an additional 5 years, it's even more material now. That's kind of the point. It becomes material because they're going to now stay for 5 additional years. Okay, I want my sign back on the building as we negotiated. And here's your lease. And here's the provision. And here's your notice. So that's a very important fact. Once they're going to stay, I need you to honor the lease. And that's the reinstatement case law that we cited in the briefs. So the lease also has a non-waiver provision in it. So you have a non-waiver provision, you have undisputed testimony that these discussions were ongoing, you have an undisputed case where he did notice it, he did ask them to put it back up, they said they would. If you were thinking of this from a statute of limitations standpoint...
Did they say they would, or they said they'd check into it?
I'd have to read the text. He said we'll have to figure out a way to replace it, I think is what the verbiage was.
Because the sign was gone at that point.
Correct. At that point, the tenant acknowledged it had been thrown out, so you're going to have to make a new one. I mean, I don't think that's a overly complicated conclusion to draw from what the facts were.
Couldn't a lot of these issues be resolved in a separate contract action for damages?
Well, I think you'd have to get an injunction you'd have to get an affirmative injunction to force them to put your sign back up. I don't know how. I mean, he could be compensated for the monetary value of a sign, but the issue is that's not the only thing that is concerning to him. It's his building, it's his company, he wanted his signage on the building, and that was expressly negotiated.
No, but it may be difficult to determine, but there's a monetary value.
I don't know that you can. I would disagree with that. So if you're talking signage, when you look at commercial leases, when you look at, let's say, a shopping center, signage is extremely important. Am I going to be on the monument sign? How big are the letters that are going to be above my store? What is it illuminated? These are all things that are usually heavily negotiated in a commercial lease context. So signage is not just about, well, it would cost you $5,000 to put a sign back.
Oh, no, I'm not saying anything about simply the value of the sign, but there's a monetary value to having it on the monument, to take your example. Couldn't a jury determine that?
I don't know how you would determine that. You're essentially proving a negative at that point. So when there's a monetary value to the cost to replace a sign, right? So we can all agree on that. That's simple. What's the monetary value of having my sign on the corner of an intersection that all of my potential customers, my general contractors who are in the area, are going to drive by and see every day? How often does the phone not ring? I don't know. How often do they hire a competitor over me? You're proving a negative at that point. So I don't think that is something that can be easily quantified when you're talking about the value of signage. Can you put a monetary value on the sign itself? Yes. Can you put a monetary value on the importance of the sign to my client, which was again specifically negotiated? No, I don't think you can. And I think that the key here, if you drill down into Malecki and Lomans, which I think we can all agree are the key cases, Lomans does not stand for the proposition that you can just not cure something. Lomans is very clear. Lomans found that the CAM charges in that case, that was a material term. It's only $3,000, but they found it was material. It's right in the ruling. What they then say is, but you can breach a material term in an immaterial way, right? So that's what they found. They said, yes, it was a material term. You got your payment 3 days late. What are really your damages here? And they said, okay, at most it's 2 or 3 days of interest, whatever the time frame was. And that's even assuming something went wrong and the facts in that case go back and forth and it's not clear they got the notice, the lease didn't say how long you had to pay, so on and so forth. So there was a lot going on in that case. In this case, the analogous situation would be they got our notice, they put a new sign up, but they put it up 33 days later. Or
in that case, there was also a time is of the essence clause in the contract, wasn't there?
I don't recall that being integral to there was, but I don't recall it being integral to the opinion.
Well, they said even in that case, when you have such an explicit contract saying this is important to us, that's only one factor the court would consider.
Absolutely. And in fact, the court said, we're not going to.
Is there anything equivalent to a times of the essence clause in this contract? What I saw was just a written statement saying the sign will stay up, not this is really important to us, this is a major negotiation point in the contract or anything like that.
There's no time of the essence clause in the extension, but every witness testified who was involved in the negotiation of that lease that was one of the key terms. The landlord, the tenant, the tenant rep who signed the lease, and the broker. They all said that was important. And the extension is not difficult. This is not a long document. I don't know what the font size is, but it's probably 18, 20, something like that. There's only 3 terms in there, and this was one of them. And that was an insisted upon term. So this, there's a couple cases that I think are most analogous. One is the Eric, A-R-I-K case that is from this court that is not a published opinion, but it's certainly a persuasive authority. In that case, you have a very similar factual setup. You have a tenant whose sign, it's reversed in terms of who had the obligation to keep the sign up. The tenant's sign was damaged in a hailstorm. The landlord's obligation was to repair it. That happened in 2010. 2 years later, in 2012, they went to renew. The landlords had some other, water and utility charges it claimed hadn't been owed, and the tenant counterclaimed and said, hey, you never replaced my sign. So they waited 2 years. And the court found on summary judgment in that case, did not need testimony, that the signage was a material component and the landlord's failure to do that was a breach. And they found on summary judgment, and that was upheld by this court. So that was a summary judgment case, giving all inferences in favor of the tenant there. So that's one. The other case that I think is most analogous is the...
How does that matter
How does
to
what
us here?
matter?
I mean, we have a bench trial where there wasn't a summary judgment. We're reviewing the facts determined, and the trial court determined, and materiality is a factual issue. You agree?
No, so if you look at Malecki, and we did state that in our brief, and then we cited other cases.
Citing the restatement says it's for the fact finder to decide, and the Arizona courts have said we have adopted the restatement in that regard.
So I'll quote Malecki for you. Malecki at page 331, paragraph 19. This is a quote. Whether Malecki was sufficiently in compliance with the lease to exercise his option to renew is a mixed question of fact and law that we reviewed de novo. So there is no deference. Now, in the next section, when they're reviewing the good faith and fair dealing section, they deal with that on an abuse of discretion standard.
Let me walk through it then again. Do you agree that the Arizona courts have adopted the Restatement 241?
Yes.
Okay. Do you agree that Restatement 241 says it's for the fact finder to decide materiality?
No, because the Malecki case, which
Okay,
addressed...
that's not my question. Does the Restatement 241 say that it's for the fact finder to determine materiality?
I would have to look at that. I don't know. I know that Malecki examined the restatement, as did Lomans, and Malecki came after Lomans, and Malecki said it's a mixed question that was reviewed de novo. So, and that's the case with waiver. That's the case with the reading of the contract, which I haven't even gotten to yet, but which the court clearly misconstrued the option provision and the definitions of the default and the breach.
Okay.
So we have a premise here where the court starts with the wrong premise.
So your position is that our standard review is de novo?
Correct. But the premise on the contract is the court first just misreads the contract entirely and says these breaches occurred before this option period, this option window, and therefore this doesn't apply. That's clearly wrong on a plain reading. Then when you look at the materiality issue, yes, that is reviewed de novo. And the first question we have to ask ourselves is this a material term? Is signage a material term? Is a covenant of you not allowed to alter my roof a material term? All the testimony, again, even if you were doing it on an abuse of discretion, everyone testified it was important and specifically negotiated. That's the definition of material. So you have a material term. The next step in the Lomans analysis is, was it a trivial breach of the material term? It's not. They took it down. They took it down intentionally. They left it down after an informal notice. They left it down after the ultimate default notice. So again, they'd taken it down temporarily and put it back up. Absolutely trivial. If they'd replaced it within 30 days, 31 days, 35 days, trivial. But they didn't. And in fact, the lease even gives them additional time. So the lease says you have 30 days. But if you commence a cure, right, and you're diligently pursuing that cure, you get more time. Very common provision in a commercial lease. They didn't do that. They literally did nothing. So you have an uncured breach. They're not acting in good faith. They're not working to cure it. They're doing nothing. And remember, they put their sign up in the exact same position. So clearly they thought this was a good place for a sign, and they wanted their sign on the building,
Can we
right?
go on and talk about the roof a bit? The only information I could find in the record talks about the repairs done, I think in 2017, were done to repair a leaky roof. What is the issue specifically with, the repairs were shoddy? What-
Yeah, if I can touch on one more thing, I didn't get to my second case. The only other quick case that I would ask the court to review is the DVMV Bricker case. And in that case, there was a covenant in the lease where it said you have to sell Arizona souvenirs. They started selling T-shirts with movie stars and comic book characters. The landlord said, this is a violation of your lease. They refused to cure it, and the court in that case upheld the right of possession of the landlord. They said, you're breaching a covenant, you're refusing to cure it, this is not trivial. They specifically cited the trivial rule even though it was before Lomans. So the Air case and the DVM case, in my opinion, control the same fact pattern here. In terms of the roof, there's no evidence of a leaky roof. My client testified he was occupying the building, right? He was occupying the building this time for the first 8 months of this extension period. The evidence on the roof is they altered it. They altered it without his consent and without his ability to choose the contractor, which is exactly what the lease says. Again, you have a clear default, which they did not tell him about. Only that section of the roof was damaged. They then concealed their prior alteration and duped him into making an insurance claim and paying for this roof. So I'll go back to trivial. Let's go to waiver. First, he only learned of that in August of 2020. He fixed it shortly thereafter. Then he learned of it. The letter was sent in October. So I don't see any circumstance where there's a waiver when he just learned about that. Number two is, in terms of the trivialness, okay, if they'd altered the roof and then they fixed it and they paid for it and they made a claim on their own insurance, yeah, that's trivial. But to cause him to put his own insurance policies at risk, to have his own premiums at risk, to pay the deductible, that's exactly what the lease is supposed to preclude. And then to say, well, you can't prove what we did in 2017 was defective, when they never told him about it, that's the whole point. The whole point of the provision is, I'm responsible as landlord for the structural part of the building. I'm responsible for paying for the structural part of the building. Therefore, you are not allowed to alter the structural part of the building. And the notion that an insurance claim, somehow he's made whole, insurance claims are very serious things. I think we can all agree that if you go through just even a calculus of, I got in a fender bender, or my damage to my car is $1,500. Do I want to make the claim? Do I want to pay the deductible? Do I want to risk increased premiums? A lot of times people don't do that. And if you make multiple claims, your insurance skyrockets. So he has a ding, and they are acting like, so what? You had insurance. Like, that it completely flaunts the covenant. So that, if I can, I'd like to save my last 3 minutes for rebuttal.
You may.
Thank you.
Counsel, when you're ready.
Morning, Your Honors. I'll try to be as brief as I can.
Let's start with our standard review. What is our standard review on materiality?
Well, I have Malecki case, the page right here that I think that he was referencing, and I don't read it to say anything of the kind. It just says whether Malecki was sufficiently in compliance with the lease to exercise his option is a mixed question of fact and law that we review de novo. The restatement, as you pointed out, is very clear on it. This doesn't say otherwise at all. So the court made findings of fact in this case, which is what my first point was going to be anyway. And basically what I hear here is...
I read Malecki saying an interpretation of a contract is a legal issue.
Yeah.
And there may be factual issues as whether you've breached that as interpreted.
Of course.
And so it's a mixed question of law and fact that would be reviewed de novo.
Sure.
But materiality itself is a separate issue, isn't it?
Yeah, I believe you have to have fact findings to determine if it was material. That's the whole point of his order, which I have here, which I commend you to read again. It's just very clear on all of these points that the court heard evidence, made findings. This court is bound to uphold those findings unless clearly erroneous. I haven't heard anything argued in the brief or today that's clearly erroneous of any finding on materiality or anything else. And I agree with the court that...
Not the court, me. I don't necessarily speak
I
for the other two
I'm
members.
sorry.
Thanks.
Right. Sorry. So, I mean, that's the major point here. They're basically arguing with the findings of fact. They don't like them. I get that. On all these points, which I could go on and on about, but they're all in the court order, which I just read again, and I think I don't need to repeat it. So,
So why hasn't your client fixed the dang sign? Put the sign back up?
well, I think the evidence, again, was that they couldn't. They had the building, as I recall, painted. The people who did it took the sign off, unbeknownst to them. It's a small sign. It's not something...
Yeah, but the landlord said, hey, my sign's missing. They said, why didn't they replace it? Why didn't they put, either that sign, if you can't get the original, have someone make a
Sure, and I think the evidence...
3 years later, especially after when they got the 30-day notice, they didn't do anything either, right? At some point, even if it's not material to at the inception, at some point, now you put on notice that this is an important issue. Why wouldn't they fix this?
Well, I was just going to
I mean,
say...
it seems like they're just thumbing their nose at this lease provision that they agreed to and everybody acknowledged was important.
Well, I don't know that we acknowledge necessarily it was important. They said it was important to them, obviously, because they're trying to defeat our option. Under paragraph 39, all this is a moot question quite candidly anyway, which I didn't hear, because as the court held in its first finding, I think, in page 2, all this is moot because the notice was clearly after the option was exercised. And that's why it's moot. It was done purposely as a pretext after we exercised the option to try to find anything they can go back and find to declare a default so that they could raise the rent or lease it to somebody else, because they knew they had no right to renegotiate it. To answer your question directly, my recollection of the testimony was, and if I'm wrong, I'll stand corrected, but this is my recollection, that what happened is that our client did look for the sign. They couldn't find it. Apparently somebody had, as I said, taken it off. It was, according to our client, my recollection is it was kind of junky at that point anyway. It was on the side of the building or something, and somebody tossed it out. We don't know who. We couldn't replace the exact sign. There was discussion, as you remember, in the text, as you pointed out, and our client was expecting him to get back to us and tell us what he wanted. He didn't. That's a fact. And so the time went by, and it's not like we said, okay, we can do anything more about it. You know, come back to us with a number and we'll pay it.
Well, but why not, surely there's some picture of the old sign.
Yeah.
Just make a new sign and market it and put it up.
Well, it could have been done 3 years earlier, I suppose, but it wasn't all that important, to answer you honestly. It wasn't all that important to the other side to make an issue of it, because they didn't. And they only made an issue of it after, under paragraph 39, they had no right to, after the option was exercised. And even then, there was no dispute at trial.
Agreed. Let's say it's ambiguous how important it is, or maybe because of the potential sale negotiations, they decide to back off that. But you get the 30-day notice in 2020. Why not fix it then?
When you say fix it, you mean replace it.
Yeah, put up either, you can't find the original, but we can get someone to make a sign that looks dang close to that one. Why not put it up?
Well, I think that we offered to do that. The testimony in the hearing that the court accepted was, and references, we did offer to do that. They never came back to, look, if we said we'll replace it and we put up a new sign, I guarantee you, based on the facts of this case, that it would never have been acceptable to them, okay? That wasn't the point. This sign wasn't important in terms of anything. It was all a pretext, and the court saw that. Anyone could see it that would listen to the testimony.
So the record would reflect that you guys offered to do that?
The record was throughout that we had no problem with paying them any reasonable amount for them to replace that sign. They never took us up on it. They never did anything. They never even sued us to this day about it. Not important to them. What was important to them was to come up with some excuse in October to find a way to deny us the option. That's what was important to them, because they knew they couldn't renegotiate under the terms as the court found. And they knew they were stuck with that $6,000 a month. They wanted to destroy our option. That's it. And they came up with this in violation of paragraph 39, contrary to what was said about them being in compliance with the lease. They weren't. That is very specific. The court cites it as the very first point. That is a major point. It was not timely. And so throughout, nevertheless, the testimony was, our client said, you know, fine, come up with a reasonable number, we'll pay you for the sign. They never got back to us for 3 years. So how important was it?
Counsel, to the extent that they suffered damages because of the missing sign and whatever the consequential cost of the roof issue, isn't that better suited in a civil damages action rather than an eviction action?
Absolutely. I mean, that's the whole point. You're absolutely on point, because that's what we argued. They never have sued for the sign value. They never even asked for the sign. They came up with, in the hearing, to show materiality, they came up with what I was able to successfully impeach to be what I felt was a phony estimate for out of state of somebody who never obviously even saw the sign. But putting that aside, because the court found in our favor on that, yeah, they never sued us for the value of the sign at all, ever, at any time, to this day. And furthermore, as far as the roof is concerned, as the court pointed out as well in our favor, they never came up with any evidence of materiality with respect to that. They only got an improved roof at both times. And why? Our client grows stuff in there, and as the court pointed out, invested a lot of money in there with lighting and so forth. We don't want water coming through there any more than they do, if not more so. So all the testimony was that we improved their property at all times, put in $3 million into it, and all they did was complain about it at the last minute to try to get us out of there. That's what this case is about. They never have sued for any of those damages. They never even came up with real damages on the insurance issue.
So a jury or a fact finder in a bench trial could determine the consequential damages for the sign and for the problems with the roof.
Could come up with it?
Yeah.
If it was an issue in the case, sure. And if the court found that was the purpose of the case.
Because your colleague,
What is it, de minimis?
yeah, your colleague said that there's no way to determine the value of a sign. Do you agree or
Well,
disagree
obviously they
with
thought
that?
there was some way because they presented evidence of it. It was bad evidence, but they presented it. So I think with all due respect to counsel, it's a little bit disingenuous to come in here and say that when he was trying to support the value of that sign and didn't succeed below. As far as the roof is concerned, they never presented any evidence that there was any damage at all. Again, it wasn't the purpose, as you point out, of the hearing, the only issue related to the materiality. But nevertheless, they presented nothing, and they still haven't sued over 1 penny of damage related to the roof.
Counsel, in this era we live in, branding is important. It seems to be...
Not to me, but go ahead.
Yeah, well, it's probably why we're here instead of someplace better. It almost seems like your position would be, and if we affirm the trial court, we're saying that, you can't make signage material. And that seems to be contrary to kind of a general principle of law, that if I own a building and I want people to know this is my building and I still own it, that I can insist that you leave my name on that building.
Mm-hmm.
And if you don't do that, it's material to me. And so how would I contract that way to do it, and how would I enforce that agreement?
Well, that's a good question. Look, I don't want to go too far here. I'm not here to talk about some other case and whether signage in some other case may be a material point. I'm not here to talk about whether or not, under the facts of a different case, it can be replaced or not. In this case, it could. So we couldn't cure it technically by putting back that sign. That's the issue. If we put back a different sign, I guarantee you they'd be in here still today arguing whatever they want to argue.
We don't know that.
Yeah,
But
so the point is, I'm not taking issue necessarily with whether or not you can make a sign material part of a default, and whether or not the cure could consist of potentially replacing it by a value. I think that's all we could do to cure in reality. It wasn't like the evidence showed that they had a problem with that. They just never pursued it.
would you agree or concede that this case, the trial court should have reached a different result if the landlord had vigorously asserted from the very beginning that the sign should be replaced?
It probably could have, yes. I think the court would have been, I mean, it's guesswork, but I think in candor to the court, had they timely noticed it, had they timely argued to the court that it was very material to them in the inception, that we were callous with it or whatever. They made a demand on us for a monetary amount at that time, and we basically rebuffed them and blew
Or
them
even
off.
if not a monetary demand, but said if you don't have that sign back up in 30 days, you're out.
Well, I'm just saying we couldn't replace that sign.
Yeah, yeah.
So I'm just saying the best we could have done was say, fine, give us a number, we'll check it out, or we'll get an estimate if you refuse to. I think if that kind of thing had gone on at that time 3 years earlier, and it was that important to them that they made a point of saying, okay, well, here's the same estimate we gave you during the trial. And we said, no, I'm not going to argue to the court that that might not be material. The court could have easily found that it would be material, and timely, by the way. That's the key. But that's not the facts of this case at all. It was 3 years later. It was never an issue. We were always willing to pay them something for it. Still are. They never have proven a reasonable value. As I said, the court did not buy a lot of their evidence, all of it for the most part, and didn't buy the signage issue either because, again, they came up with this sign estimate late during the trial. It was from out of state. There was no evidence from that individual. It appeared to the court, I believe, to be a phony estimate, and it was not a realistic estimate the court found for that particular sign looking at it.
Let me change gears just a little bit.
Sure.
I know Eric is not a published case from our court, but I read it and it seems pretty persuasive to me. So tell me why Eric should not be controlling. And that's the one involving the sign repair and the landlord not repairing the tenant's sign.
Well, I don't know really honestly how to answer that other than it isn't controlling, but, and I think that the court, again, I can only honestly say, made factual findings in this case that found that in this case it wasn't controlling. As I said earlier, I'm not here to argue that in some other case, different facts, different contract, different paragraph 39, different time when they made it material and argued that, it's not there and we're going to proceed on a default. And then what would have happened then? Let's just play that out. Under Arendt or any other case. What would have happened? Would we have forfeited, the court said, a $3 million investment in the balance of our lease for this sign that he found, the court found specifically to be no big deal in looking at it? The answer is obviously, I can honestly say no. At that point, had they made a legitimate demand, which counsels almost admitted they didn't, and said, this is a default, you've got 30 days to cure it. If you can't replace it, which they knew we couldn't because there were the text messages, then we're going to proceed, in which case what would have happened? Clearly, they would have presented some evidence of value, we would have paid it to avoid the default, and that would be the end of this, or we would have offered to pay it. That's the worst case scenario that I can see under any case that could apply here. But again, paragraph 39 is clear. The court made a big point of it. I don't think it's a matter of interpretation of a contract for a de novo review. It says what it says. They're not arguing what it says. Never have. Just was untimely. And again, not to belabor it, but it was untimely in bad faith. Okay? It was untimely in bad faith because it was obvious to everybody that listened to the evidence that this was not a legitimate exercise, contrary to counsel's impassioned argument. It is not a legitimate exercise of anything at that point in time, other than to specifically deprive my client of the benefit of their bargain. That's what it was. It was not designed legitimately, because if it was, I would agree with you, 3 years earlier it would have been resolved. And it never was. And they had a means to do that. And so to say, well, after you exercise your option and we know we're stuck, that suddenly this becomes the most important issue in the world, the Shoals sign, that was probably this big, is now the indispensable condition of our lives, is just not believable, wasn't believable, and frankly, I think the court saw through all of it, and I think this court should too. So, materiality, to repeat, I believe to be a factual finding that was made. I think the court has to rely, however you look at that legally, on the factual findings of the court that heard the evidence about whether it was material. How could you determine in a vacuum whether it is material without facts to support that finding? It would have to be, at least, as you said earlier, a mixed question at a minimum, and that portion of the question clearly has to be a fact finding in order for the court to determine that it's immaterial.
Mr. Willencheck, can you address the attorney's fees argument as
Oh,
well?
sorry. Thank you. Thank you for reminding me of that. Yeah, I'll be brief on it. I said I'd be brief on everything, but you know how that goes. Basically, I'll summarize it this way. I believe that under the law, it's established numerous cases in Arizona, I don't think it's within an area of dispute, really, that it's in 12-341-01 directly, that a contract should not be ignored regardless of the fact that you can get fall under the statute separately if you don't have a specific provision that arising out of the contract can get attorney's fees. And the exact language, I can't put my finger on it at the moment, but it's something to the effect that the preamble, as I recall it, of 12-341, that the right to contract for fees shall not be impaired in any way by what follows, or something to that effect.
But the lease, provide for an award of reasonable attorney's fees. Isn't that within the discretion of the trial judge?
My recollection is that the lease provides that the reasonableness issue, and that's why this is kind of unique, is based upon what the client reasonably pays. A little different than the statute. We believe the client reasonably paid every penny of those fees, obviously, without obviously sounding too self-serving. This was a serious issue, and they pursued this over a matter of weeks in trial, very seriously, and they're good lawyers, and I take nothing away from them, and they pursued this extremely vigorously. My client was looking at complete forfeiture, and with all due respect to the lower court on this issue, I think that he was a little cavalier in terms of lopping off fees.
But there were objections made, and the court reviewed those objections and said some of these fees are reasonable and some of them weren't. You want us to defer to the factual findings on materiality, but you don't want us to defer to the factual findings on reasonableness?
No, I wouldn't say that, and I appreciate your comment, and I would sound obviously more than disingenuous if I were to say otherwise, but what I'm saying is that I think the test that he used did not consider what the contract actually says in terms of that finding, that's all. The contract is a little different than the statute, that's all I'm saying.
So you're saying that the contract, basically, by defining reasonableness as whatever they pay, means it's whatever you pay?
You have to find out what they paid. Yeah, I know it sounds difficult, but... I understand. But it specifically, I think, was designed to say, look, if the client pays that, then it's presumed to be reasonable, okay? And yes, could a court, I would have to agree with you, could a court ultimately determine what is reasonable that the client paid? I suppose the answer is yes. The only quibble I have is I don't think the court used that standard. I don't think so, that's all.
Well, so really what you're saying is that you disagree with the court's...
I'm more than a fool to tell you with this time I have left that winning a case on reversing attorney's fees would be an easy task for anyone. I get that. I'm just saying that I believe that the standard of the contract is not the same as the statute, and the court did not consider that and utilize that. Whether he would have found the same thing, I'm not going to tell you otherwise because I don't know, and I wouldn't necessarily quibble with your position on that.
Thank you, Mr. Williams.
Thank you.
Counsel, when you're ready.
Judge, let me just hit on a few points, if I may. The first point is the question of whether a contract term is material. That is a legal question in terms of looking at the contract and determining, is this something that was specifically negotiated? That is very clear, and the facts are undisputed in this case. Every witness who testified on the contract said it was important. It was one of the only things that was in the lease extension. So the issue of whether something was material, my position is a de novo review. The issue of whether the breach itself was trivial, I think I would agree, that is a factual determination. However, again here, the breach was removing the sign and literally never replacing it.
Important and material are not the same thing.
That's actually the definition of material is important, and it's actually what the case law says.
Important is a subjective thing. It may be very important to someone, But that does not make it material for purposes of the lease.
The case law is if it's something that's specifically bargained for, and this was specifically
The
bargained for.
case
and
law
every-
is,
and
there's
every-
a 5-factor test that goes through a whole bunch of things that are all factual issues
That's-
that need to be determined whether it is material or not.
That is to determine whether,
So it might be, for example, it's very important that you pay your payment on time.
yeah.
Okay, that doesn't make it a material provision of a lease.
The extent to which the injured party will be deprived of the benefit he reasonably expected, that's number one.
That's one of them, yeah.
Right, that's number one. The extent to which the injured party can be
That's
adequate.
that's probably the important part. That, I would agree, that's
I don't know if I'd
the
read out-
subjective, whether it's important to the person who entered into the
I'm
agreement.
not sure I'd read out the other 4 clauses as unimportant. There's 5 clauses, none of which are stressed as more important than the other. So,
But no, I mean, but that's the one that kind of, you've covered point A there, that it was important to the landlord subjectively that this thing.
And was
I would say that's
negotiated-
covered by number 1.
the idea that this was only raised in 2020 is just outright false. It's in the lease. It's one of only 3 provisions on a 1-page document. So clearly it's important. And they acknowledged it. Everyone acknowledged it. It's an undisputed fact. So there is no fact here to decide, like Malecki. Were they substantially in compliance? Did the square footage not match the original calculation? Did they tender a payment? Like Loman's, did they mail it to the right address? Was it 3 days late? There are 0 facts for this court to consider on the trivialness of the breach, because the breach happened and was never cured. So that distinguishes this case from the prior 2 cases, which effectively, in my position, is bad facts make bad law. You had some really bad facts in those cases for the landlords, where they were really overreaching. Here, all they had to do was put up the sign. Put up our sign for the next 5 years. That's all my client wants. Make the claim on your insurance. That's all my client wants. The fact that these are somehow uncurable, impossible things to comply with, then why'd they agree to them in the first place? And if we're going to say you don't need to comply with your covenants, even after a proper notice and a reasonable period to cure, even if they would have started it, that would have been enough. Got 6 seconds. I just want to make 2 quick points. There was no findings at the trial court on bad faith, none whatsoever. So I would refute all of that. And there was no tender ever made, and no evidence of any tender ever made, even for the cost of the sign. But the cost of the sign is not the only issue here. The issue is it's his building, it's a negotiated term.
Thank you, counsel.
Thank you, Your Honor.
We thank you both for your arguments here today. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.